opposed to the Colorado Oil and Gas Conservation Commission. The COGCC's hearing room is being expanded to accommodate the good work that we're doing over there. And so we don't have a space that is large like this to accommodate all of you. So thank you for joining us here today. My name is Jeff Robbins. I was appointed by Governor Jared Polis and DNR Executive Director Dan Gibbs to serve as the Director of the Colorado Oil and Gas Conservation Commission last year. In this role, it is my duty, along with the entire agency staff, to ensure that the state of Colorado's oil and gas operations are conducted in a manner that is protective of health, safety, welfare, wildlife, and the environment. This mandate was highlighted with the passage of Senate Bill 19-181 last April, which instructs our agency to undertake historic rulemakings to strengthen those protections for all Coloradans. We take this charge to heart and will deliver to the spirit and mandates of the law. Today, we are here because more protections can and must be put in place. On April 17th, 2017, the unthinkable tragedy happened in Firestone that forever changed the lives of the Martinez family. Our hearts still grieve for Aaron Martinez's family members who lost their lives during this tragedy. We are here today to learn from the tragedy at Firestone, where Aaron Martinez lost her husband, Mark, and her brother, Joey Irwin. In their honor, COGCC and I are committed to protecting every person's safety in oil and gas operations. COGCC takes to heart that we must protect the public safety in and around oil and gas operations, and we have responded to the Firestone tragedy. We have undertaken several actions. First, under Senate Bill 19-181, COGCC is undertaking rigorous rulemaking to ensure protections are ingrained in the fabric of our rules and the foundation of what we do. One of the first COGCC rulemakings following enactment of 19-181 was our focus on increasing the protections around flow lines. Learning from the tragedy of Firestone, we increased the protections to the public through stronger and more transparent flow line rulemaking this past November. Also, the COGCC continues to work with operators to make sure they comply with COGCC rules. We have teams of inspectors that work to determine if and how an operator may be out of compliance. We have an enforcement team that backs up the work of these inspectors. COGCC is charged with ensuring operators comply with our rules, and we have the enforcement tools and measures to ensure operators come into compliance. Today, we are here to announce that we have issued a notice of alleged violation to Kier-McGee, which is the subsidiary of Occidental Petroleum, for the Firestone tragedy, which occurred April 17th, 2017. The NOAV, the Notice of Alleged Violation, alleges violations of 4 of our rules. The number of days of the violation alleged for each violation is 365 days, which is the maximum number of days permitted by statute. The maximum daily penalty assessed for each violation is between $10,000 and $15,000 a day. Again, the maximum penalty that can be assessed. There is no discount applied to any of the violations, which often occurs, but it does not occur in this case. We have also applied an aggravating factor. The aggravating factor of death has been applied, which increases the penalty. And this is the first time this aggravating factor has been applied. The aggravating factor increases one of the penalties from $3.6 million to $5.4 million. Today, the COGCC has issued the NOAV and will be seeking $18.25 million against Occidental and Kier-McGee for the Firestone tragedy. Importantly, a majority of this penalty will be used to fund special projects relevant to flow line monitoring and air emissions, and will help to increase public safety. I note this is the largest penalty ever sought by COGCC by more than 11 times. However, due to the violations and the loss of lives, COGCC believes this is appropriate. The next steps in this process are that Kier-McGee, Occidental Petroleum, will answer to the commission for these violations. The commission will consider this NOAV at its special hearing, which is scheduled for 1 p.m. on April 6, 2020. And this will be held here again because of our work at the commission at the Ralph L. Carr Colorado Justice Center. COGCC and I, as director, believe that today's response is fair and appropriate. We know it won't ever mean that the Martinez family will have their loved ones returned, but with today's decision, we are using every tool possible to the COGCC to be able to avoid any future tragedies. Again, I want to thank all of you for coming and being here. I will now take questions. Before I do that, I want to introduce two COGCC managers who have contributed to today's announcement, and they're available to help with technical assistance. This is Mike Leonard, our acting field operations manager, and Mimi Larson, our hearings and regulatory affairs manager. As Megan Castle noted, we will first take questions from those in the room, and then if you would text your questions to Megan's cell phone, we'll take questions from folks that are not in the room. And Chris Aaron will help us with the questions.
Jeff, you're seeking $18.25 million, but what's the reality that the state will get $18.25 million?
Well, first, we have to have a commission hearing on this. The commission will hear it on April 6th, and it is up to the commission after listening to the parties to determine whether this is the appropriate fine. But we believe that this is fair and responsible and appropriate. And if the commission were to adopt it as an order, that order would become final, and Occidental would need, and Kier-McGee would need to comply with that order. I have had discussions and negotiations with Occidental about this and believe that they will be ready, willing, and able to comply with the order. In particular, they have been involved in the special projects discussions that I pointed out, and they are ready, willing, and able to accept and fund those projects.
Hi. Can you please explain what this company did wrong that caused this tragedy?
There were several instances that contributed to this tragedy. I would point out that the number of things that took place are difficult to replicate in terms of having those things happen again. But the pipeline at issue was cut off, and was disconnected, and then later it was reconnected. And there was not sufficient verification of the reconnection to ensure that when it was reconnected, it was flowing back to the tank battery. And instead it was not. And that led to the tragedy at issue here.
Can you put that in layman's terms, what happened here?
A pipeline was severed, and it remained severed with the gas not flowing into the pipeline. And then at a subsequent later date, gas was allowed to flow into that severed pipeline, which contributed to the tragedy.
Two questions. Has Kier-McGee indicated that they will fight this $8.25 million?
I have had discussions with Kier-McGee concerning this matter. We do not have their answer at this point. The NOAV has issued this morning, and so we will need Kier-McGee to have the appropriate due process to file an answer. And so we will wait to see from that, but we have worked with Kier-McGee relevant to getting to this NOAV and the four issues as well as the fines that are assessed.
And then my second question, SB 181 passed last year. How much higher is this fine because of that new law than it would have been had you been issuing fines a couple years ago?
Yeah, I appreciate the question. SB 181 did not elevate the fines associated that we are presenting today, SB 181 did bring to light the new mandate of the commission. And so it ensured that we are looking at this with the correct lens, but it did not actually look at increased fines.
Commissioner, we're 3 years out from the tragedy, and I think a few months away from the report that came out that detailed exactly what happened from the federal government. Why did this take as long as it took?
A couple of answers to that question. First, the commission was deferring to the NTSB process to allow that process to work out, so that we did not get ahead of that with regard to our moving forward with a NOAV. Second, the commission entered into a tolling agreement with Kira-McGee so that we would have an ability to fully enforce an NOAV at a subsequent date. Generally, we have to act within 1 year of an incident. That tolling agreement allowed us to take additional time. And then this took time because this is a significant incident. This is a significant action on the part of the commission, and we wanted to make sure that we got it right.
Do you wish it happened sooner?
I'm sorry?
Do you wish it happened sooner?
I wanted to make sure that we got it right. And I think that is what we have been able to do by taking the considered time to get to this point.
I apologize if you already said this earlier. Does the Martinez family get anything from this fine, or is this simply going to the state?
Thank you for that question. No, this fine goes to the state. The Martinez family has been involved and is aware of the actions that we are taking. We felt it all prudent to ensure that they were involved, but the monies and the special projects that are funded by this are attributable to the state, and that's just via state statute.
Yeah, what is the process for Kira-McGee should they want to fight this? Once the commission makes its decision, is that final, or can they appeal that?
Yeah. So the next steps are Kira-McGee will have an opportunity to answer to the notice of alleged violation. And then after they file their answer, this would go to a hearing before the Colorado Oil and Gas Conservation Commission. And as I mentioned, that hearing is on April 6th at 1 p.m. here in this building. At that hearing, Kira-McGee is afforded due process to state their case as to whether they accept or want to rebut the elements of the notice of alleged violation. The commission then is the final deciding body, and they will make their decision. Kira-McGee would, if they are not accepting to the commission's decision, have an ability to take that to court.
Hi, Greg Avery with the Denver Business Journal. I'm curious, you indicated that you've spoken with the Martinez family about this. Is the family supportive of the conclusions you've reached?
We have engaged the Martinez family in these discussions. I am going to let the Martinez family speak for themselves. They're aware of this morning, and I believe that they have a statement.
And thanks for allowing a follow-up. The environmental monitoring penalties that are outlined in here, are these above and beyond what is likely to be required of the company anyway, under the rulemakings that you guys are, in terms of the methane detection and some of that stuff?
Yeah.
Is this above and beyond what the COGCC would typically require of a company?
Yeah. So typically, COGCC, under its enforcement wing, will find a violation, issue a notice of alleged violation, have assessed a monetary penalty. The monetary penalty is typically paid and placed in our environmental response fund, where it is used for, in large part, plugging and abandoning our orphan well program. In this case, given the significance of the fine, we have worked with Kira-McGee to establish these special projects for air emissions and air monitoring, which go above and beyond what we normally would do. We needed Kier McGee's consent to be able to work with this. And while we've not worked through the process, as I mentioned in my last answer, we are hopeful that we will be able to work through the process to allow these special projects to be funded in honor of the Martinez family and in honor of 181, and doing things correctly and using this money in a proactive manner.
There are signs that the oil and gas industry could be headed for some financial turmoil. How confident are you in the ability of your agency to, have the capacity to address, possibly have seen a lot more abandoned wells and things like this related to the Firestone tragedy going forward?
We are confident in our ability to fully utilize our orphan well program to plug and abandon wells that are needed to be plugged and abandoned. We're also confident in the state of the oil and gas industry and that they will be able to work with us in that regard.
I'm sorry, I was looking at my phone. I don't know if that was the question I was about to ask, which is, we've been reporting now for nearly 3 years on actions taken after this explosion to try to prevent it from happening again. Are you confident that the action taken is sufficient?
I am confident that based upon a number of things that are occurring at the Colorado Oil and Gas Commission, that we are taking action items to prevent this sort of tragedy from ever occurring again. Not only are we assessing a fine today, but we are assessing special projects, and we are also updating our flow line rules, as I noted. And we are taking aggressive and fundamental transformative rulemakings over the course of the next several months at the commission, all in line to satisfy the mandate of SB 19181 to ensure that we're regulating oil and gas in a manner that's protective of human lives and people and wildlife and the environment.
I know you kind of addressed this in terms of the process through the commission, and then if Kier McGee isn't happy with this, they could go to court. In terms of negotiating this, is this a hard 18.25 million, if you don't like it, take us to court? And if that happens, how long are we talking about? Or do you have the flexibility to negotiate without having to go to court?
Notice of alleged violations at all times involve discretion on the part of myself as director, as well as on the part of the Colorado Oil and Gas Commission, who is the final arbiter of a potential violation, whether it be one of this sort of significance or any other one. At this time, I remain firm that this $18.25 million for violation in OAV is the right place to be. It'll ultimately be up to the commission as to whether this is the correct place to be. If Kier McGee were to disagree, they have the statutory ability to appeal this to courts, and the court process takes whatever the court process is.
So from the commission standpoint, if they agree, whatever the commission votes on in terms of the money, it's that or?
That's right.
Could another party, such as Martinez family, for example, seek any sort of action against the commission should they feel like the penalty is not enough? If they ultimately decide, let's lower it to $10 million, $1 million.
As an example, the Martinez family is aware of what we're doing. I anticipate that they would be at the commission hearing and would be addressing the commission, which is an important component to the important work that we're doing here. Whether or not they have standing to challenge that later is not actually something I have information about, but we can certainly, try to get that back to you. Ms. Castle, do we have folks on the line that have questions?
You know what? We have no questions that have come in, but if folks on the line want to send me some, we did have questions, they were answered. So, are there any other questions from folks in the room? Okay. Okay,
Seeing none, thank you all. We really